Okay, what I want to do now is cover the pretrial conference statement and focus on the stipulations page. You're at a mandatory settlement conference, you don't have an attorney, and you're setting the case for trial, either the case in chief, setting it for trial on AOE, COE, a dispute maybe over the level of permanent disability. Whatever that dispute is, you're setting it for trial, and you'll need to complete the pretrial conference statement. The first page that you're going to get to is the stipulations page, and what we'll do is go through those. Number one, your name and your date of birth should be relatively straightforward. We shouldn't see fights there. If there's a dispute over whether or not you were an employee, it will either be employed or allegedly employed. And then you're going to have the date of injury or the date of the cumulative trauma. Both of those should be straightforward based on the application that was filed and what the doctors have found. You'll have your occupation. If you and the defense attorney or you and the insurance representative agree on your job title, that's good. And you have an occupational group number. If you are not sure what the correct occupational group number is for you, do not agree to it on the stipulations page. If you're not sure if it's maybe a 380 or a 390 or a 350 or a 351, leave that section blank. The issue there is that if you stipulate to something, when it goes to the trial judge, he or she is going to look at that stipulation, know that that issue is done, it's been agreed to by you, and move on to the other issues. If you are not sure what the correct occupational group number is, do not stipulate to it. Leave that area blank, or you can write in dispute. You'll list it as an issue on the next page, the issues. The point there, don't stipulate to something if you're not sure. Moving down, the name of the employer, where you were working, what city you were working in. Now, sustained injury arising out of and in the course of employment, that will be for accepted body parts. So the employer admits that you injured your low back, but let's say the employer denies that you also have gastrointestinal problems as a compensable consequence. On that first line, sustained injury, AOE, COE, it's going to be the back, the accepted body part. And then claims to have sustained injury will be the gastrointestinal or whatever the employer is disputing. At the time of the injury, the carrier was just the name of the insurance company. We get to number 3, and that's your earnings. So what your average weekly wage was. If you are sure as to that number, if the employer has provided records or you and the defense attorney have gotten together and you have an agreement on that, that's good. List the agreed rate. If you're not in agreement, don't list something there. Again, if it lists earnings there as a stipulation, that means that you and the defense attorney agree on that number. If you don't agree on the number, don't list it as a stipulation. Number 4 will be benefits that were paid. So the defense attorney should have a printout of benefits listing temporary disability, permanent disability advances, and any medical that's been paid. So any benefits paid to you, the temporary disability and permanent disability, should be listed there. The employer or the employee has been adequately compensated for all periods of temporary disability. That box can be checked and the date can be inserted if you agree that you've been paid all of the temporary disability that you believe you are owed. If there is still a dispute as to temporary disability, if you feel that you took time off work and the employer didn't pay you temporary disability, then don't check that box because it's an issue. Again, you check that box when it goes to the trial judge. He or she is going to say, I don't have to worry about temporary disability. Everything is stipulated to. So if it's an issue, don't insert information there on the stipulations page. Many times when I was a trial judge, the information would come to me and I would tell the injured worker, I see here that you've already stipulated that you've been paid all of your temporary disability. And the injured worker would say, well, actually, I still think I'm owed money. That's a problem for the trial judge and a problem for the injured worker because you've already stipulated that you've been paid everything that you should have been. So the primary treating physician, you can list the doctor's name there. No attorney's fees have been paid. If you don't have an attorney now and you haven't had an attorney, that box will be checked because no attorney's fees have been paid. And then other stipulations. So that would be anything that you and the defense attorney both agree to in your case. Maybe you both agree on the permanent disability that the doctor found, but you're disputing apportionment. Or maybe you and the defense attorney both agree that all the benefits have been paid out and it's just a dispute over medical treatment. Whatever you and the defense attorney agree to can be listed as other stipulations. And again, if the defense attorney writes something on there and you don't agree to it, don't just sign that form and figure you will talk to the trial judge about it. That needs to be stricken or put a line through it there at the mandatory settlement conference. So that's the stipulations page. It's everything that both parties agree to. It gets more interesting on the issues page, which follows, and that's a separate video. Tune in to that one next.